All right, so we're diving deep today into Australian corporate law, going to unpack these directors' duties right. I got my hands on some super interesting postgraduate stuff from the University of Canberra. Plus, we'll be looking at a real-life legal case later.
Sounds fascinating. Always good to refresh the basics.
For sure, especially for anyone working in or with companies, these duties are like the foundation.
Couldn't agree more.
So these materials, they lay out two main groups of duties.
Fair.
One's from like all the court decisions over time.
Case law, yeah.
Exactly. And then the others set out in the Corporations Act.
That's it. The 2001 one, we've got duties like acting in good faith, being careful and diligent, avoiding conflicts of interest. All those developed over time through, precedents.
So it's like those case law duties, they become official in the Act.
Exactly, yeah. They're codified. The Act has specific sections that are basically the same as those case law principles, so they're actually legally enforceable. Like Section 180, that's all about duty of care and diligence. Then 181 is good faith, and 182 and 183 are about using your position the wrong way, like for personal gain.
Okay, so those statutory duties, that's where things get serious, like with enforcement.
Yeah, absolutely. ASIC, that's the Australian Securities and Investments Commission, they have the power to actually go after directors who break these statutory duties. We're talking potentially serious stuff. Civil penalties, disqualification, even criminal charges in some cases.
Wow, no kidding, high stakes then. Seems like really understanding these duties is crucial for anyone in that director role. Let's start with the duty of care and diligence. The materials mentioned an objective test. What's that all about?
Basically, it's not about judging a director's intentions, but like their actions, right? It's more like, what would a reasonable person in the same position, how would they have acted in similar circumstances? So not about being perfect, but meeting a reasonable standard.
So not what the director thought was best, but what someone, knowledgeable and skilled, what they would have done.
Yeah, exactly. The University of Canberra materials, they have some good real-world examples of what could be a breach of this duty. Like if a director just keeps skipping board meetings without a good reason, or doesn't even bother to stay informed about the company's finances, or doesn't try to understand the risks the business faces, all that stuff, those are red flags.
So being a director, it's more than just a title, right? You actually got to be involved, informed, participating in the big decisions.
Oh, for sure. But the law also recognizes that business means making judgment calls, taking risks. That's where the business judgment rule comes in.
Okay, so does that basically protect directors from, like, liability if their decisions, even if they were made carefully, turn out bad?
It's not a blanket protection, no, but it's a possible defense if a director can show they met certain conditions. Like, first, they have to show they made the decision in good faith, truly believing it was best for the company.
So no personal gain from the decision, no conflicts of interest.
Right. And second, they got to show they really informed themselves about the situation. Did they gather all the info, maybe get expert advice, really think about the potential consequences?
So no rash decisions, got to do your homework. What's the last condition?
They have to rationally believe the decision was in the company's best interest. Even if, looking back, it turned out poorly, if they had a good reason for believing that at the time and met those other conditions, the business judgment rule might protect them.
So it's not about guaranteeing success. It's about making those decisions responsibly. Now let's talk about good faith. It seems like that's woven through all these duties. What does it actually mean for a director to act in good faith?
It basically means genuinely believing that you're doing what's best for the company. There's a subjective element, like did the director honestly think they were doing the right thing? But also an objective one. Would a reasonable person in their shoes have felt the same?
So you can't just say you had good intentions if your actions were totally reckless or like any sensible person wouldn't have done that.
Exactly. Let's look at a real example. The James Hardie case, a big one in Australian corporate law.
I remember that name. It was a huge deal, right? Something to do with asbestos claims, if I remember right?
Yeah, that's the one. James Hardie, they were facing a ton of compensation claims related to asbestos exposure. The directors, they decided to set up a foundation to handle these claims, but it turned out to be way underfunded.
So they were accused of breaching their duties by setting up a foundation that couldn't actually do what it was supposed to do.
Yeah, pretty much. ASIC claimed the directors hadn't been careful enough, hadn't ensured the foundation had enough money, and this case went all the way to the High Court.
And what did they decide? I bet this set a big precedent for directors' duties.
It did. The court found that a few of the directors, they had breached their duty of care. They'd approved a misleading press release about the foundation's funding. This case really shook up the corporate world, made everyone realize how seriously they needed to take these duties.
Really shows that these duties aren't just, like, theoretical. They have serious consequences. I bet a lot of directors were sweating after that ruling.
Oh, I'm sure. The James Hardie case, it's a powerful reminder that fulfilling your duties as a director, it's not just about staying out of legal trouble, it's about ethical conduct, making responsible decisions.
Speaking of ethical conduct, let's move to the duty to avoid conflicts of interest.
Mhm.
Seems simple, but I bet in practice it gets pretty messy.
You're not wrong. It boils down to avoiding situations where your personal interests could clash with what's best for the company. Putting the company first, basically, avoiding even the appearance of doing something shady.
So, no using your position to make yourself, your family, or your friends richer, even if you think the company's getting a good deal.
Right, like a classic example is a director who owns shares in company A, and that company wants to do business with company B, where the director also sits on the board. Even if the deal looks good on paper, there's a big potential for bias there.
It's about avoiding those gray areas where your judgment could be clouded.
Right.
Right. Now, what if a director does have a potential conflict? Can they do anything besides just resigning from the board?
Transparency is the key. Directors, they got to disclose any big personal interest to the board. And they shouldn't vote on anything where there's a conflict. It's about making sure decisions are objective and there's no undue influence.
Makes sense. Better to be safe than sorry and be open about potential conflicts. Now, the materials mentioned the ASIC action against Star Entertainment Group directors. What was that about?
Oh, yeah. ASIC is going after a bunch of current and former directors of the Star, saying they breached their duty of care and diligence. The allegations are about failing to handle money laundering risks and criminal stuff within the Star.
So it's not just financial mismanagement. It's about the company being ethical and following the law.
Exactly. ASIC's argument is that the directors, they didn't do enough to understand and deal with these risks, even though they had info that should have set off alarm bells. It shows that directors, they have a broad responsibility to make sure the company is operating legally, ethically, responsibly.
And this case is a big deal because ASIC is going after the whole board, right?
That's right. The first time they've done that for a Section 180 breach since the central litigation, that was a landmark case all about financial reporting failures.
So they're sending a message about collective responsibility, the board working together to fulfill these duties.
Exactly. It shows directors can't just delegate and ignore problems. They have a duty altogether to make sure the company's operating legally and ethically.
Powerful reminder that being a director, it comes with big responsibilities and big consequences. Okay, so we've talked about care and diligence, good faith, avoiding conflicts of interest.
And we've seen how those duties play out in real life, right? With potentially serious consequences for directors who don't measure up. But it's not just about avoiding legal trouble. It's about ethical conduct, making good decisions, and strong corporate governance.
Absolutely. Sounds like being a director is tough, but also super important.
You got it. Those decisions they make, they have a big impact, not just on the company, but on employees, shareholders, the whole community. It's a role that needs a real understanding of the law, strong ethics, and a commitment to acting in the best interests of everyone involved.
Well said. Seems like we've only scratched the surface. This is a complex and fascinating topic.
Totally agree. There's a lot more to unpack.
Welcome back. All right. So we've been looking at these directors' duties, both the case law stuff and what's in the Corporations Act.
Yeah, it's fascinating, It's not just law, it's ethics, business strategy, the whole impact a company has.
Totally. We talked about care and diligence, good faith, avoiding conflicts. But in the real world, directors can't be experts on everything, right? How much can they actually rely on other people's info or advice without, putting themselves at risk?
It's a good question. It's tricky. The law knows directors need to rely on others sometimes, but they can't just, pass the buck entirely.
So how do you know where that line is? When does reasonable reliance become, negligence?
Well, Section 189 of the Corporations Act, that gives some guidance. Directors can rely on info from others, but only under certain conditions.
Okay, so what are those, what are the safeguards?
The big one is that reliance has got to be in good faith. The director has to actually believe the info is accurate, reliable.
So no ignoring red flags, no pretending you didn't see a problem.
Exactly. You can't just bury your head in the sand.
Yeah.
And the second thing is the director needs to have made their own assessment of the information, independent.
So they can't just take it at face value, even if it's coming from, a big shot consultant.
Nope. They got to use their own knowledge, their experience, really look at the info, see if it makes sense with what they know about the company and the situation.
So even with advice from the top experts, still got to apply your own judgment, ask the hard questions.
For sure. How much scrutiny you need, it depends, right? A small operational detail, maybe not so much. But a huge strategic decision based on like complex financial stuff,
Yeah.
that needs way more careful assessment.
Makes sense. You're
Yeah.
bringing your own expertise to the table, even when you're using info from others.
Exactly. And ASIC v. Healy, the Centro case, that's a perfect example of what not to do.
Yeah, the one where the directors signed off on those messed up financial
Yes,
reports.
that's it. They tried to say they were just relying on advice from management, the auditors, but the court didn't buy it.
Why not? What went wrong?
The court said the directors hadn't really looked at the info themselves. They didn't question anything, didn't dig into the details, no skepticism, even though there were warning signs.
So basically, blindly trusting experts or using bad information without doing your own homework, that's a disaster waiting to happen, even if you say you were acting in good faith.
You got it. Directors, they got to find that balance, trusting experts, but also, being a bit skeptical.
Okay, makes sense. Now let's talk about delegation. Directors can't do every single thing themselves.
Right, they have to delegate effectively, but where's the line between delegating properly and just, shirking your responsibility as a director?
Yeah, where's that balance?
Well, Section 198D of the Act, that talks about directors delegating their powers and functions.
So they can delegate, but within limits.
Absolutely. They can delegate to like a committee of directors, another director, an employee, even someone outside the company. But it's got to be all documented properly, in the company's records.
So everything's above board, transparent. What about things that can't be delegated? Are there any?
Oh, yeah. Some things are non-delegable. The Centra case actually made that clear. Directors of public companies, they can't delegate their responsibility for the financial reporting. That's on them.
So signing off on those financials, that's the director's job. No passing the buck there.
Exactly. And even when delegation arrests allowed, it doesn't mean the director is off the hook completely.
Meaning, if they delegate something and the person messes up, the director's still responsible.
Yep, Section 190 makes that clear. Directors are responsible for the actions of those they delegate to.
So how can directors protect themselves if something goes wrong with a delegated task?
There are two main things that can protect them. First, they gotta have reasonably believed that the person they delegated to would exercise that power properly, following the director's duties under the Act and the company's constitution.
So they can't delegate something super important to someone they know is, like, incompetent or untrustworthy. They got to believe the person can handle it, will be responsible. What's the second thing?
The director also has to have reasonably believed in good faith and after making inquiries that the person was competent and reliable.
So not just blind trust. Got to do some checking, look at qualifications, make sure they have the skills and experience.
Yeah, exactly. How much inquiry you need, it depends. If it's a simple task to a trusted employee, maybe a quick chat is enough. But a complex, risky decision to, like, an outside consultant, that needs a much closer look.
So directors got to think carefully about who they delegate to and how much oversight is needed. Delegation's a tool, but not for avoiding responsibility.
Exactly. It's about empowering people to help the company succeed while also making sure everything aligns with the director's duties, staying accountable.
This has been really helpful, clearing up all this stuff about delegation and relying on information. Both are important for good management, but they need careful thought and common sense.
Totally agree. It's about that balance, trusting others, but also doing what you need to do as a director.
Now, before we wrap up this part, I want to go back to something we touched on earlier. Directors being personally liable. That's when things get serious, right?
Oh, for sure. We talked about ASIC going after directors with civil penalties, even criminal charges. But those consequences, they can go beyond just the company. They can hit the individuals directly.
So directors aren't protected just because they're acting for the company. Their own decisions can have consequences for them personally.
That's right. Personal liability, it's a strong deterrent. Make sure directors take their duties seriously. It reminds them their decisions have real effects, not just for the company, but for their careers, their money, their reputation.
Okay, so let's break down how W directors can be held personally liable under Australian law. What are the big risk areas?
One big one, like we said, is breaching the Corporations Act. ASIC can go after directors with civil penalties if they don't meet those statutory duties.
So we're talking fines, being disqualified from being a director, even having to personally pay the company back for losses. Right.
Exactly. ASIC, they have a crucial role enforcing the law and protecting shareholders and the community.
So even if the company itself doesn't sue the director, ASIC can step in.
Yep, they're the watchdog, making sure those breaches don't go unpunished. And on top of those civil penalties, there's also criminal charges in some cases.
I'm guessing that's only for the really serious stuff.
Yeah, usually cases of dishonesty, fraud, or recklessness. Like Section 184 of the Act, that talks about criminal offenses for directors who act dishonestly or recklessly.
So we're talking intentional wrongdoing, lying to people,
Yeah.
completely disregarding the law and the company's interests.
Exactly. Criminal charges, that's a high bar, but the consequences are huge.
Yeah.
Big fines, jail time, and of course, your reputation's ruined.
It shows that directors' duties, it's not just about good governance, it's about being honest, upholding the law. High stakes, serious consequences.
Absolutely. And besides the Corporations Act, directors can also be personally liable for the company's debts, especially if it becomes insolvent.
Hold on, so even if a director didn't do anything wrong themselves, they could still be on the hook for the company's debts.
In certain cases, yes. Australian law has rules about insolvent trading, when a company keeps racking up debts, even though it can't pay them back.
Makes sense. That protects the creditors from getting screwed over.
Exactly. Insolvent trading, that can be disastrous for creditors, especially small businesses or individuals who can't afford to lose that money.
So how does the law prevent that? What are directors supposed to do?
Section 588G of the Act, that talks about the duty to prevent insolvent trading. It applies to directors who knew or should have known that the company was insolvent when it was taking on more debt.
Okay, a few questions there. First, what does insolvent actually mean? What are the signs a company's in trouble?
There's no single definition, but usually a company's insolvent when it can't pay its debts when they're due.
So it's not just about assets, it's about cash flow, being able to actually pay the bills.
Right. Some common signs are like trouble paying suppliers on time, always needing to extend payment terms, relying more and more on overdrafts or short-term loans, missing tax payments, getting sued by creditors, not being able to get new financing.
Those are pretty clear warning signs that something's wrong financially.
Yeah.
What are directors supposed to do if they think the company might be insolvent?
They can't just ignore it and hope for the best. They have to take steps to stop the company from getting even deeper in debt.
Like what kind of steps?
It depends, but it could be things like getting advice from insolvency experts or restructuring specialists, maybe negotiating payment plans with creditors, looking at raising capital or restructuring the business, or even appointing an administrator to take control.
So being proactive, taking steps to protect the creditors and try to fix the situation.
Exactly. The duty to prevent insolvent trading, that's a serious one, and if you breach it, the consequences can be big. Personal liability for debts, civil penalties, even criminal charges sometimes.
Sounds like a high-pressure situation. Directors need to understand the finances, spot those warning signs, and be ready to act.
Totally. That's why it's so important for directors to stay informed about their legal obligations, get good advice when they need it. It's about protecting themselves, the company, and everyone involved.
Okay, so we've talked about a lot of ways directors can be personally liable. Breaking the Corporations Act, criminal offenses, insolvent trading.
Yeah, it's a lot to keep in mind. Directors need to understand those risks and take their duties seriously.
Absolutely. Now let's move on to disclosure obligations.
Sounds good.
We've talked about being transparent, honest, especially with conflicts of interest. But are there actual legal requirements for disclosing certain information?
You're right. We've touched on that. Disclosure obligations, they're a fundamental part of good corporate governance. It's about making sure directors are acting honestly, avoiding conflicts, and giving shareholders the info they need to make decisions.
Okay, so what specifically are directors required to disclose under Australian law?
One of the most important things is personal interests in matters that come before the board. Section 191 of the Act, that's the one that requires directors to disclose any material personal interests they have in something the board is considering.
What exactly is a material personal interest? It seems pretty broad.
It is broad. It basically means any interest that could influence a director's judgment or decisions. So that could be
Okay, go on.
direct financial interests, like owning shares in a company that's trying to get a contract. Indirect financial interests, like if your spouse or someone in your family has a financial stake in a company that could benefit from a board decision.
Makes sense.
Personal relationships, like being close friends with someone who could benefit even if there's no direct financial link.
Okay.
And conflicts of duty, like if you're also a director of another company that's got a competing interest.
So basically, being transparent about anything that could put your personal interests against the company's interest.
Exactly. And if you don't disclose a material personal interest, that's breaking your statutory duty, and you could be hit with those civil penalties we talked about. Transparency builds trust, makes sure decisions are made for the right reasons.
Like that saying, sunlight's the best disinfectant, right?
Yeah.
Better to be open than try to hide stuff.
For sure. Now, besides personal interests, there are also rules about related party transactions.
What are those?
Transactions between a public company and its related parties, which could be directors, their families, other entities they control. Chapter 2E of the Act, that sets out the rules.
Why do those transactions need special rules?
Because there's a higher chance of conflicts of interest and maybe even abuse. If a director's on both sides of deal, they might put their own interests ahead of the company's.
Like, don't mix business with pleasure. It's about protecting the company from directors giving themselves or their buddies a sweet deal.
Exactly. And to avoid that, these transactions usually need shareholder approval.
So the shareholders get to decide if the deal's fair, if it's good for the company.
That's right. The company has to put together a document explaining the transaction, the good and bad, the director's interests. Then that goes to the shareholders at a meeting, and they vote.
So the people who could be hurt by a conflict, they get to decide.
Exactly. Shareholder approval, that's a big safeguard against self-dealing. Make sure things are done fairly and openly.
Are there any exceptions to that? Do all related party transactions need shareholder approval?
There are a few exceptions, yeah, mainly for transactions that are arm's length, meaning they're done on the same terms as if the parties weren't related.
So like if a director buys office supplies from their own company, but the price is the same as everyone else pays, that might be arm's length.
It might be, but the company has to prove it's truly arm's length. It's usually safer to just get shareholder approval, even if you think it's obviously arm's length.
Good advice. Now, what about listed companies? Do they have any extra disclosure stuff?
Yep, they do. Listed companies have to constantly disclose info to the market, anything that could affect their share price. That's in the ASIC listing rules.
So it's about investors having the right info to make good trading decisions.
Exactly. These continuous disclosure obligations, they cover a lot of stuff. Anything a reasonable person would think could affect the company's share price.
Okay, give me some examples. What kind of info triggers this continuous disclosure?
Well, it includes things like
Okay, go on.
significant financial results, good or bad,
Mm-hmm.
big new contracts or acquisitions,
Right.
changes in management for mining companies, new mineral discoveries or resource upgrades,
Got it.
regulatory approvals or setbacks,
Makes sense.
legal proceedings or investigations.
So it's a wide net, catching all kinds of financial, operational, strategic stuff that investors need to know about.
That's right. And if the listed company doesn't do this, the consequences are serious.
We're talking ASIC action, fines, even criminal charges, right? Plus, shareholders wouldn't be happy to find out they were kept in the dark.
You got it. Shareholder class actions are a risk, too, where investors sue because they lost money due to the lack of disclosure.
So transparency and timely disclosure, those are non-negotiable for listed companies.
Absolutely. It's all about a level playing field for investors and keeping the market fair. Companies that mess with that are taking a big risk.
Okay, I think we've covered a lot on these disclosure obligations.
Mm.
It really shows how important transparency and accountability are in the corporate world.
Yeah, for sure. These obligations are crucial for building trust with shareholders, investors, and the whole community.
Now, before we move on, let's circle back to the business judgment rule. Remember that. Seems like a key concept for directors, especially when they have to make tough decisions.
Yep, important one. It's kind of a safety net for directors who are acting honestly, doing their best, but things just don't work out.
So it recognizes that business is risky.
Right.
Not every decision will be perfect, right? But it doesn't protect recklessness or negligence.
Exactly. The business judgment rule, that's in Section 182 of the Act, it can be a defense against breaching the duty of care and diligence, but only if certain things are true.
All right, break it down for us. What does a director need to show to use this defense?
Well, first, they have to show they made the decision in good faith for a proper purpose. That goes back to those basic duties we talked about. The director has to truly believe they were doing what's best for the company, no hidden agendas or anything.
So no personal gain, no ulterior motives, just trying to do what's good for the company. What else?
They also have to show they didn't have a material personal interest in the outcome. That's not just financial, it's anything that could make them biased.
So if a director's spouse is a big shareholder in a company that's bidding for a contract, that's a problem.
Definitely. The director has to be able to show their decision was based on the company's interests, not their own or their close connections.
Okay, what's next?
They have to have informed themselves about the decision, to a reasonable extent.
So no gut feelings, got to gather the info, maybe get expert advice, consider the consequences.
Yep. They have to show they thought it through. And lastly, the director has to rationally believe the decision is in the company's best interest.
So even if it doesn't work out, if they followed a good process and truly thought they were acting in the company's best interest, they might be protected.
That's the idea. It lets directors take informed risks, knowing that not everything will be a success. But it's not an excuse for carelessness. They still have to be careful, skillful, and diligent.
Fine line, right. Protecting directors, but also holding them accountable.
It is. The business judgment rule, it's part of that balance. It's important for directors, but they have to use it responsibly only when it's really appropriate.
Well, we've covered a lot in this section, that's for sure. We talked about diligence when relying on information and advice, all the details of delegation, the different ways directors can be personally liable, and all those disclosure obligations.
Yep, we've unpacked some complex stuff, but it's all about giving directors the knowledge they need to do this job right.
Absolutely. And in our final part, we'll shift gears a bit and talk about practical strategies directors can use to actually fulfill their duties, manage risks, and help their companies succeed.
Sounds good. We'll be back soon to wrap things up and share those valuable insights.
Welcome back. So in the last two parts, we went deep, right? Directors' duties in Australia, all the legal stuff, the risks, being transparent, all that.
Yeah, it can feel a bit overwhelming, all those responsibilities, the consequences.
Totally. But for this last part, let's get practical. What can directors actually do to handle all this effectively, responsibly?
Well, I'd say one of the best things is to commit to always learning. The laws change, best practices change, it's ongoing.
What are some good ways to stay up to date?
The AICD, the Australian Institute of Company Directors, they're great. They've got courses, programs specifically for directors, covering everything from the basics of the law to more specialized stuff like risk management, finance, ESG reporting.
So directors can really focus on what they need, what's relevant to their industry.
Exactly. And besides formal courses, you got to stay on top of industry trends, legal changes, subscribing to legal updates, going to conferences, even just talking to other directors. That all helps.
Like building a network, sharing experiences, knowledge.
Exactly. And don't be afraid to get expert advice when you need it. Lawyers who specialize in this stuff, accountants, risk consultants, they can give you specific guidance for tricky situations.
Asking for help isn't a weakness, it's smart. Shows you're committed to making good decisions.
Couldn't agree more. Now, besides staying informed, what are some practical things day to day to manage those risks and fulfill your duties?
Yeah, how do you actually do it all?
It starts with having a strong system of corporate governance, right? Clear policies, procedures, documenting decisions, having ways to monitor compliance.
So it's not just knowing the rules, it's making those good governance practices part of how the company works.
You got it. That framework, it creates accountability, reduces risks, makes it easier for everyone to do things the right way legally.
Okay, that makes sense. So what about daily stuff? What can directors do to make sure they're fulfilling their duties?
Being active on a good board, that's crucial. A diverse board with different skills, regular productive meetings, open communication, all that.
So not just showing up, but really participating, asking questions, making sure everyone's voice is heard.
Exactly. Each director, they have to contribute, bring their expertise to the table when making decisions.
Okay, so what about when it's time to actually make those decisions? Any tips for making sure they're responsible in line with all those duties?
A big one is to document why you made the decision, the thought process behind it.
So if someone questions it later, you can show how you got there, that you did your due diligence.
Exactly. And remember that duty of care and diligence, part of that is staying informed, about the company's operations, the finances.
So looking at the financials regularly, asking management questions, understanding the big risks, being engaged, proactive.
That's it. Directors can't just sit back and wait for information. They got to go get it, think critically, and if something seems off, dig deeper. And if they're not financial experts, get help from someone who is.
Right. Know your limits, get expert help when you need it. What about conflicts of interest? We talked about disclosure, but how do you actually handle those situations?
Well, having a clear policy on conflicts of interest is a good start. It should say what the company expects, how to deal with conflicts, disclosing them, recusing yourself from decisions when there's a conflict.
So a framework for everyone to follow, not just leaving it up to individuals.
Exactly. And even beyond the policy, it's about being aware, sensitive to conflicts, even ones that seem small or indirect.
So if a director's friend is bidding on a contract, even if the director doesn't have a financial stake, they should still tell the board about it, just to avoid any appearance of a conflict.
That's the idea. Transparency maintains trust, make sure decisions are objective. Now, another tricky area can be whistleblowers.
Those are the people who raise concerns about, like, wrongdoing in the company.
Yep, often employees. And it's crucial to make them feel safe coming forward.
So that means having a clear way to report concerns, protecting them from retaliation, taking those allegations seriously.
Exactly. Directors should have a good whistleblowing policy. How to report, confidentiality, no retaliation for speaking up.
It's about making it okay to raise concerns, showing it's a good thing, not disloyal.
Right. And when someone does report something, directors have to make sure it's investigated properly, impartially. Ignoring it, dismissing it, that can really hurt the company legally and reputationally.
It sends a bad message, like wrongdoing is okay, which hurts trust and ultimately hurts the company's value.
It's about doing the right thing, legally and ethically.
This has been great. So much good info. We covered a lot, the legal stuff, the risks, and those practical tips for fulfilling duties and handling tough situations.
It is a lot, but important for anyone who as a director or wants to be one.
So what's the one big takeaway from all this?
I'd say being a director, it's a privilege and a responsibility. It's not just meetings and a paycheck, it's making decisions that affect people's lives. It's about integrity, following the law, making those tough calls, thinking about the company, A&D, the community.
It's about being a steward, not just for shareholders, but for everyone.
Well said. And by staying informed, getting advice, having strong systems, acting ethically, directors can handle this role and make a real positive difference.
Thank you so much for all your expertise. This has been a great deep dive into directors' duties in Australia.
My pleasure. It's something I care about, and I hope we've given our listeners what they need to navigate this complex world.
And to everyone listening, thanks for joining us. Keep learning, stay engaged, and strive for excellence in everything you do.